We say, my lady, it's a state's case that the accused was a deceitful witness. The court should have no difficulty in rejecting his core version of events, not only as not reasonably possibly true, but in essence as being absolutely devoid of any truth. We say he failed to demonstrate that the scene was contaminated, disturbed, and tampered with. The version of the accused will be served a severe blow should the court accept the evidence of Colonel van Rensburg and Warrant Officer van Staden. If the court accepts that that's a true reflection of the scene discovered by van Rensburg, the court will have no option but to reject the accused's version. His version cannot be reasonably possibly true if that was the scene on the morning of 14 February. If the fan was in front of the door, the duvet was on the floor, and if the denim jeans were lying on top of the duvet, the accused mosaic would lack any cohesion. There's just no version. That cannot be explained. It's impossible to explain that.
If that fan was there early that morning when Colonel van Rensburg was there, how did he walk through that door? And how did he not, A, the fan was blocking, that's the state's own case, conceded by the defense, and B, if that fan was on, so much the more if the fan was there, he would have known it. He doesn't know about it. It shows inadvertently things could have moved. The police come in, the fan is right between the radio and the bed. It's in their way. They didn't think at that time something would turn on a fan. Why would they have thought that? Move it away. I can understand it. I can understand it, and that's all the accused was saying. The one thing we would ask the court when the court considers our argument is, we know on the facts that Dr. and Mrs. Stipp, and to some extent Mr. Slingetwa, heard the first shots. And then the second sounds, that's also described as shots, were then heard by this Dr. and Mrs. Stipp again, and then Mrs. Berger and Mrs. Johnson. And we were waiting for the state to tell the court what were those first shots. And you will not find the answer in his heads of argument, and you will not find the answer in his argument. And one thing you cannot do in a criminal trial, you cannot ignore a serious, material, objective fact. You cannot do that. And the state has done it. I know why the state has done it. Because it will cause a nosedive of their case on the 317 description, what they described as shots. They also don't deal with the cricket bat striking the door because they cannot. But we'll deal with that.